Hey there, everybody. So, Donald Trump's been president now for a little over 72 hours. He's issued well over 100 executive orders. One of the biggest ones that have come out of that stack is the executive order to end birthright citizenship. Now, birthright citizenship, as we all know, is granted in the Constitution under the 14th Amendment that was passed in 1868. Prior to that, Congress had passed the Civil Rights Act of 1866, which also granted birthright citizenship with the restriction that as long as they didn't fall under the jurisdiction of a foreign power. So why are we even talking about this? Well, as everyone knows or may not know, a federal judge blocked Donald Trump's birthright citizenship executive order and has put it on a temporary hold, saying that it is blatantly unconstitutional, amongst a myriad of other reasons. Also, during this time, 22 states so far, probably primarily blue states, have all filed suit against the Trump administration in regards to his executive order to end birthright citizenship. So out of that, Donald Trump's attorneys, the good old boys from the Department of Justice, have filed their pleadings, and a lot of their argument is based upon the language that goes back to the Civil Rights Act of 1866 and also the 14th Amendment. And in there, part of their argument is where they tie in the fact that Native Americans were not considered citizens under the Civil Rights Act of 1866 or under the 14th Amendment because of the language that says something along the lines of subject to the jurisdiction of. Now, you go forward a few more years to 1884, and there was a case styled Elk v. Wilkins, in which a Native American man by the name of John Elk was denied the right to vote. He filed suit claiming that he was a citizen based upon the 14th Amendment. That case goes to the Supreme Court, and the Supreme Court in 1884 rules that Native Americans do not have birthright citizenship under the 14th Amendment because they were not subject to the jurisdiction of the United States at the time the 14th Amendment was passed, which, if you think about it, that's why they passed the Indian Citizen Act of 1924 that granted Native Americans citizenship in the United States in our own land, right? Now, what makes all this so difficult to explain in a clear, concise explanation is because when it comes to Indians and the Indian policy and the treatment of Native Americans in this country, there has never been a bright line rule or law when it comes to Indian law cases. It's always based upon the whim of Congress. It's always based upon the whim of the justices that are in the Supreme Court at the time, because more often than not, instead of them coming up with bright line rules like they do in every other areas of law, when it comes to Indian law cases, it's based upon the outcome or the decision that they want to have versus the decision or outcome that they should make based upon what is actually right and what has been decided previously. An example I can give you is the Bracker balancing test or the Montana rule. All those are there for the mere purpose of making it harder for Native American tribes to enforce and have their treaty rights enforced, to actually win cases. They're there to limit us. And I said this in another TikTok that I made, but when I was in law school, I hated federal Indian law. I hated it because everything that you learn about federal Indian law, you learn that is there to limit and restrict Indians and Indian tribes. It's not there to help us. It's not there for the good of Indian people. Even some of the so-called cases and statutes that are supposedly favorable to Native Americans, they're basically there to restrict us. Indian Self-Determination Act. You know, one would think that that's a good law because it gave Native American tribes the right to self-determine themselves and to guide themselves in the direction that they want, that they deem fit. But it's under the guise of having to ask the Bureau of Indian Affairs and the Indian Health Service for our allocation for our money so that we can operate our tribal governments. So is that real self-determination when an Indian tribe is having to go to the BIA or to the Indian Health Service and show them that we're worthy to be allocated these funds that are set aside for us? Not really. If you look at other laws that are supposedly favorable for Indian tribes, like the Indian Child Welfare Act, right, of 1978, again, you know, we're having to convince the state that we're worthy to be able to make the decisions for our own kids. The Indian Gaming Regulatory Act, another bone that was thrown at us from Congress, that basically says that if we want to engage in Class 3 gaming, that we must enter into a compact with the state that we reside in, right? How is that self-determination? How is that self-governance when we have to go to the state that we reside in order to reach a compact that is almost more often than not favorable to the state? Otherwise, they can just say, well, we don't want it. We're not going to allow it. And even worse, if you're an Indian tribe in a state that doesn't even allow gaming, like Utah, you can't even engage in Class 3 gaming or Class 2 gaming for that matter. You know, how sovereign are we? How self-determined are we if we can't even operate our tribal government without having to jump over these hurdles that Congress has placed on us through all these different laws? Sorry, I got a little bit off track there, but back to the birthright citizenship issue. So why are Native Americans not considered to have birthright citizenship under the 14th Amendment? Well, if you go back and you look at the history of the relationship between Indian tribes and the federal government, when you go all the way back to the, say, 1700s, and the first treaty that was made between the Indian tribe, the Delaware tribe, and the United States was made in 1787. And over the next 90 years, 88, 90 years or so, a lot of Indian tribes made treaties with the United States. So from that regard, when you look at the language that was in the Civil Rights Act of 1866 that said one is granted birthright citizenship as long as they don't fall under the jurisdiction of a foreign power, or if you look at the language in the 14th Amendment that was ratified in 1868 that says you have birthright citizenship as long as you're not subject to the jurisdiction of somebody else. And in the case of Native American tribes, we were still back in the 1700s and a majority of the 1800s still operating as independent nations separate from the United States. So when you have that treaty making power and authority and your treaties state that you're independent, that you're separate, that you're not part of the United States, we were not subject to the laws or the jurisdiction of the United States. Even when you go to 1830, right, or 1831, in the Marshall Trilogy case, Cherokee Nation versus Georgia, where Justice Marshall, in his famous ruling, opined that Native Americans are not independent, they're not foreign, they're not a foreign nation, nor are they a state. And he labeled us as domestic dependent nations, or he compared Indian tribes that and the relationship between Indian tribes in the United States as that to a guardian and a ward. And unfortunately, it stuck. However, even past that point of 1830, Indian tribes were still making treaties with the United States. Shine-Arapaho tribes, my own tribe, Treaty of 1851, Treaty of 1861, Treaty of 1865, Medicine's Lodge Treaty of 1867. The last treaty that was made between an Indian tribe and the United States was in 1868, the Fort Laramie Treaty. It wasn't until 3 years later when Congress passed the Indian Appropriations Act, which basically ended all treaty making between the United States and any Indian tribe, and basically deemed and labeled all Indian tribes to be dependent domestic nations, no longer independent, which all those dates are kind of kooky, but they all kind of tie in. But the Indian Appropriations Act of 1871, which ended the treaty-making authority between the United States and Indian tribes, occurred 3 years after the 14th Amendment, 5 years after the Civil Rights Act of 1866. So up until that point, Indian tribes would still have been considered to be independent and not subject to the jurisdiction of the United States, which is why in that court ruling under Elk v. Wilkins in 1884, they ruled that Mr. Elk was not a citizen by the birthright citizenship of the 14th Amendment, because at the time he was born, it would have been before the Indian Appropriations Act. The downside is that as a result of Donald Trump's birthright citizenship executive order in which he's trying to end it, the unfortunate downside to that is now that 22 states have sued his administration, the attorneys from DOJ are now having to file their pleadings to justify why they believe that the language in the 14th Amendment does not apply to the people of today. They're trying to argue that it only applied to the former slaves back in that time period. It is very unfortunate that the argument they're using is Native Americans and that we were not subject to the jurisdiction. It's really a very weak argument, but it's an argument nonetheless. And it's an argument that's going to have to be litigated. It's going to have to be litigated not only by probably the ACLU, right? Not only the 22 tribes that have filed suit so far, but my guess is that some other tribes, some of the larger tribes or the tribes that have deep pockets are also going to engage in this litigation and are probably going to file suit against the Trump administration. It wouldn't even surprise me if the Native American Rights Fund files suit against the Trump administration. And what they typically do in large class action cases like that is they'll ask Indian tribes to sign on or to write an amicus brief on behalf of their brief that they're going to file. So where does that leave us at today? Does that mean that Indian tribes and its citizens can no longer hold dual citizenship in their own tribe and the United States? I don't believe that is the case. I don't believe that the executive order is going to stand up in court. I think the plain language of the 14th Amendment as it applies is going to be able to withstand the Trump administration. I truly do. I also believe that the decades, over 100 years of Indian law cases that have come and gone since that time are also going to be able to withstand the Trump administration. The fact that the Indian Citizenship Act granted Native Americans citizenship in this country is not going to take away our ability to also have dual citizenship in our own tribes, simultaneously having citizenship in the United States. That being said, Indian tribes can certainly not sit back and hope for the best. We have to be proactive. We have to be vigilant. As I said in another TikTok that I had made on another topic, Indian tribes are used to fighting. We're warriors. We were here before the United States was the United States. We were here before they came over from Europe. We're going to be here long after. But that means that we always have to continue to fight and stay vigilant, fight for our rights, fight for our people, fight for our existence, because that's who we are as Indian people. We're used to it. We're not going to stop. We're not going to sit back and hope that somebody else fights this battle for us. We're going to fight our own battles. We're going to be a part of this battle going forward, and we will fight that battle for the next 4 years. So with that, all of the tribes out there, work together, band together. Let's come together on these key issues. We see each other all the time at all of the national conferences that many of us attend, that many tribal leaders attend, that many attorneys attend. You know, I have a small work group with some of my colleagues in the law field, in the tribal leader space, that I can reach out to and that they can reach out to me. We're just going to have to duplicate that on a much larger level. You know, NCAI, the National Congress of American Indians, some of the other larger Native American organizations like the Native American Finance Officers Association, we're all going to have to band together, stick together, help one another, lead one another. This is a tough time. This is a scary time for many of our people. You know, it wasn't so long ago, 75 years ago, the Indian tribes were going through the termination era. And keep in mind, and I've stated this before as well, the United States government has a short-term memory when it comes to upholding their own promises of what they say they will do. They expect everybody else to uphold their promises made to them, but they don't mind breaking them on a whim. And they have a short-term memory when it comes to upholding their end of a bargain on anything. And when you think about the termination era back in the 50s, about all them tribes that lost their federal recognition because of the policy of how to work with Indian tribes has always been like this. And they got hit on a down cycle in the 50s. That came less than 10 years after World War II, in which code talkers from the Navajo tribe, Comanche tribe, Cheyenne tribe, other tribes that had code talkers helped the United States win the war against Japan. Had it not been for the code talkers, the Native American tribes, the only codes that the Japanese were not able to break, the United States would have lost World War II. But it wasn't even 10 years later that the policy had shifted again from the Indian Reorganization Act era to the termination era, because the United States government has a very short-term memory when it comes to upholding their bargain. And it's up to us as tribal leaders and attorneys and advocates and anybody else that cares about our people to fight on our behalf. I'll see everybody out there. Let's fight the good fight. Aho.